stay subject to depositor 50% of the monthly maintenance regularly and arrears 50,000.
Arrears?
In arrears, 50,000 was directly deposited. Here, court has ordered 20,000, but they have also 15,000 arrears and there is a 15,000 per month is directed.
In the order?
Yes.
And
let's see tomorrow. Yes.
I have filed a recalling application. The matter was posted on in the last occasion, but that is lordship passed the order needs the partner. Then, my lord, it's order that posted the matter for intervocation. But day after tomorrow, matter is before the trial court. That's all. No, my lord. So if it is not recalled, my lord, then
what is recalled? What is to be recalled? I'm not able to understand.
Application for recalling application.
What is the order? What is recall?
We dismissed for non-prosecution.
When is it dismissed for non-prosecution?
9/3/2024, madam. That's why, my lord, I have filed a recalling application.
You should have been there before the court when the matter is there.
No, my lord, I was held up in total number 2, my lord.
See, you have to understand all of you. It is becoming an exercise for the court.
Sorry, my lord.
Take it. Take that.
Well,
tomorrow.
Please.
Yes.
CRP matter not listed.
Not listed. Why?
Being spoken, order dismissal.
Tomorrow?
Please.
Page 1, page number 6, page number 18 to 21.
20. You appear for whom? You are for the petitioner. It is submitted that there is a likelihood of settlement with this matter after winter vacation. Stay granted again is extended. Give a date. Yes. 16. Use the mic.
Both sides of counsel has to file their asset and liability of the parties.
After winter vacation 25.
Stage and stage.
Enter stay granted again is extended till then. You appear for the petition. Who appears for the respondent? See, at the request after interrogation, give a date.
17.
17.
17. 17. 2 days time will be back.
No 2 days time. It will go after vacation. Yes. 17. Have you informed the other side? Yes. 17 after vacation. Give some date. Don't give all on the same day. Already, I think, till February 15th or 16th, January, dates are given. Thereafter, 1 matter, 1 Monday. Yes. Yes.
Page number 25 to 28.
Serial number 27.
It's a CP. Why after vacation?
Some documents in the police before the court.
Who appears for the respondent? At the request of and call for the petitioner, does this matter after vacation? Give a date. Yes, before. Yes.
Serial number 29, my lord.
May I request tomorrow because the connected matter is posted tomorrow, my lords.
What is the number?
There is an order for clubbing in that matter, my lords.
Okay. Post along with so and so tomorrow.
Please.
Serial number 32, madam.
30?
32.
Uh,
Daughter of the Christian Council, she is hospitalized. She is a driver. It will kindly be taken on after vacation.
after vacation and the request. Yes.
Page number 10, serial number 36 to 40.
Submission, serial number 24. Next week. For connected appeal.
What about, have you informed the other side?
And appellant in the connected appeal.
That's what, have you informed the other side?
So,
Wait, wait till the matter reaches. Yes.
This is number 1. One very important is number 1. Until the end, who was denied.
Lords, I appear for the respondent husband, my lords. My lords, as discussed earlier, your lordship, husband has also sought for divorce, my lords. He is insisting upon the divorce, my lords.
No, what she says is already that that the memo is prepared, wife has signed. What's
Yes,
the difficulty? What is the
he is
difficulty?
respondent husband, my lords, is seeking for, is insisting upon the divorce, your lordships. He is ready to pay one-time settlement, my lords, subject to she agreeing for the divorce, my lords.
No, that was not what he stated before the court on the last occasion.
My lords, it was listed in chambers, my lords. He had
No, that's not correct. That was not his case on that day.
he had sought for divorce, my lords. It is
This is as far as the maintenance is concerned.
yes, my
Up to
lords.
the one-time settlement. Even that day she said that she's not inclined to give divorce. What is? He's also 65 years old, I think.
Yes, my lords. Lords, I request for some time, my lords. Will
This matter, the request of the counsel to the husband after vacation.
please.
Yes.
Authorized. Serial number 2. Anil Kalex. Signature code.
Kindly pass over. This file compromise text we have.
In the chambers. Two. Yes, in the chambers. Yes.
Also, serial number 3. C.A. Shutter.
A week's time report order. Yes, next.
Serial
4
number 4. Serial number 230.
weeks time report order. 5
Serial number 5. J. Shetty.
on the maintainability. What is the maintainability?
Order has been passed in regular appeal
Oh.
under 7 rule 11,
Oh.
saying that the appeal is not maintained. In fact, it is not. Specific performance has been decreed as part against the decree, it has been filed. They say that because the plaintiff already filed miscellaneous application for setting aside expired. That application came to be rejected. There are the miscellaneous appeal has been filed. That came to be withdrawn to liberty to file the appropriate remedy. Then appeal has been filed. Appeal dismissed on the ground that there is no once miscellaneous appeal has been dismissed. That's why it did not. It's not correct.
No. What has happened to the suit?
Suit is decreed ex parte.
Ex parte decree.
Ex parte
No,
decree.
then
Initially, the petitioner has filed an application under
Before the very same
9
court.
rule 30,
Oh, yes.
before the very same court, for setting aside ex parte decree. That has been came to be rejected.
and then again is
Then
that
against which he filed a miscellaneous appeal.
Oh.
Then on proper advice that he can also file a regular appeal in view of the Supreme Court decision. But he filed a regular appeal. Now the regular appeal court dismissed the application by exercising power under 7 rule 11. That is strange. In fact, it's not. Refusal amounts to refusal to exercise the jurisdiction by the
because it is order 7 rule 11 rejected. This rejection the officers raised objection.
Yes. In fact, it is amounts to refusal to
Let's see that order.
It amounts to refusal to exercise the jurisdiction. Lordship, may kindly see
Page number
order, page number 13.
13.
Yes. The reasoning is at page number 8.
According to the court, you should have filed a revision. CRP.
What they say is that because 9/13 application is rejected, you should have filed a
Revision before the High
revision
Court.
before. But it's not correct. In fact, both your lordship is well aware that in so far as the ex parte decree is concerned, both the remedy is available.
But here it is like this.
But suppose
Having filed an order 9 Rule 13 petition.
Malad, it can be. Malad, that's why
Malad, where is the judgment?
that Malad, I will. Malad, in fact, it is.
Next
In
week.
fact,
I mean, this is matter day after tomorrow.
Number 6, Mediation.
1 week, then some office objection is right. Malad, I will file.
This is matter after vacation. At the request of non-counsel petition. Yes.
Number 7.
What happened to 6? What happened to 6? Huh?
60, right.
5 and 6 are
Or connected. Oh, yes.
But office objection at serial number 3 is with regard to clarification of name, age and occupation of the petitioner, which were wrongly shown before the family court. Whatever shown in the first title is correct. And in so far as
No, not like that. You have to show how it is shown before the trial court.
But if it was wrong, then I have to.
No, then like you can mention it. Whatever it has to be carried as it is, and you should say they note before below that.
So 3 and 4 are with regard to very same petitioner and respondent. I'll clarify it.
Office objections should be clarified within a week.
Please.
This is matter after the objections are cleared or after vacation. Yes. Yes.
Number 8, DSMP.
Please, ma'am. I filed the retirement memo and also allowing acknowledgement on the 3 floor ma'am.
You appear for the petitioner? Then counsel Mr. B.S. Sankhi is permitted, have filed a memo, the memo of retirement. The same is taken on record and is permitted to retire. So and so submits that he is going to file wakalat. He has instructions to file wakalat. He will file wakalat. This is matter after winter vacation, and by the time the counsel of the petitioner shall comply with the office objection.
27. 27. Number 9.
List after service of notice.
I appear on behalf of
Respondent.
This matter we have already served the copy. It's again introduced as summary.
It is as per the order passed by this court. The petitioner has taken out hand summons of the counsel appearing with the respondent before the trial court. That is Mr. G.M. Hegde, and filed a memo to that effect. Accordingly, notice to the respondent is insufficient. The office is directed to reflect the name of the party. Intermodal granted earlier is extended in the next state of hearing. This is matter in March. Yes.
Number 10.
My lord, I'm presenting on behalf of the petition, my lord. 1 week short accommodation in order to comply the office objection. Please do.
Because it's all before vacation in all these weeks matters. Office objections to be complied by January 15th in all
Yes.
the matters, even in the earlier matters also, January 15th.
Please.
Today I have created a video and I will serve copies.
You're already filed.
No, it's already copied.
So you appear for the respondent.
Yes, ma'am.
Sole respondent.
Yes, ma'am.
Sole respondent.
Yes, ma'am. It's a transfer petition, my lord. They have filed it.
You can hear it. Anyhow, you want to file objection?
I will take the instruction and I will file
The
the
so and so submits that. He has instructions. 1 minute. So and so submits that. He has instructions to file the ballot on behalf of the respondent. Yes. What do you want to say?
Wife is ready to join. It may be referred to mediation in the month of January.
And counsel for the petitioner submits that the wife is ready to join the husband. Both the parties shall appear before the mediation center on 7th of January.
Please.
Take him, so and so, take his name, is filing on Karnataka. Yes, next.
No, 7th is Saturday.
Huh?
7th of
7th of January is Tuesday.
Please, sorry.
You are looking this year calendar.
Sorry.
So, next.
With your order,
Center board order granted is extended to the next date of the next.
Seal number 12.
Hmm.
Going for answer.
What also, non-taking of hand summons by the advocate was petitioner, await service on
But in
notice.
this matter, Honorable Court has passed an interim order for the monthly payment of 3,000 per month as a monthly mechanism to continue the month. In the interim order, it has been reflected as 5,000.
How much is the amount granted by the court?
3,000. In the interim order, it has been.
No, by the trial court.
Trial court 4,000.
Interim order is shown as
5,000.
then counsel for the petitioner. Submits that how can it be? Who has taken this? BB. When the trial court grants 4,000, the maintenance how this court will grant 8,000 and for that on a stay 4,000. It is submitted that the trial court is granted 4,000, and though the order is passed for this court on the condition of paying 3,000 rupees, but the order reflects as 5,000. Accordingly, the order dated 25/11/2024 is modified, and the stay is granted on the condition of paying an amount of 3,000 per month by 5th of every succeeding month, and shall deposit the arrears at 3,000 within a period of 8 weeks from the date of earlier order.
Yes.
From the date of receipt. When did you receive this order?
It's on 2/12/2020.
From 8 weeks from 2/12.
Great.
hearing on the seal number 30. All subs you be here.
Yes, 39 days is pending.
Who appears?
Second.
CRP arises out of
I number 1 of 2019 is filed to condone the delay of 39 days in file. There is no representation on behalf of the respondent. Considering the reasons stated, the delay of 39 days is condoned. This is matter for admission tomorrow or day after tomorrow.
What alone, the main appeal is pending, the RSA is pending. The pendency of the RSA original appellant died. Now the person who has come on record claims to have been lectured. The original appellant has bequeathed the property in his favor based on a will. Now these findings recorded on the will by the trial court is challenged in this year. So unless it has to be clubbed along with the main, the reason why I am challenging is
The connected appeal is pending before this court, list along with so and so. Yes. No, list not after tomorrow. List along with that whenever it is coming. Yes.
Seal number 14. J. Swaraj, J. Malali.
Yes.
Petitioner is a husband.
Who appears the respondent?
Vijay sir appeared.
J. Malali.
I number 1 of 2023 is filed to condone the delay of 10 days. No representation of the respondent for the reasons stated in the accompanying affidavit. The delay of 10 days is condoned. This is matter for admission on preliminary hearing on preliminary day after tomorrow. Yes. Next.
Seal number 15.
Notice. Notice.
Pursuant to this order, the respondent member came and lived with the petitioner hearing and lived for 2 years more. And subsequently she filed a recovery petition.
No, that's true.
Okay.
Let there be notice. It's a delay of 923 days.
Yes.
Notice to the respondent.
Seal number 16. CS
Notice.
On the submission knowledge, the petitioner is a disabled person knowledge. He is having a 63% disability of age.
No, but that is true. But you came after 310 days.
He was not appearing, couldn't approach the trial court counsel knowledge. When the attachment to others, he has undergone 1 month imprisonment knowledge. Recovery petition has been filed by the wife. He has undergone 1 month imprisonment and the person. Managed to kindly see page number 87. We have produced the disability certificate. He is also having diabetic neuropathy, my lord. He cannot walk properly, walk or move.
Where is that?
Page number 87, my lord. Page number 87 is the disability certificate, my lord. And page number 94, there is the discharge summary report. 15,000 rupees has been awarded by the trial court. He is unable to work, my lord. He is dependent on his brother. And she is working, my lord. She is earning, she is an assistant teacher and earning more than 24,000, which is also admitted by one her assets and liability affidavit.
What is he doing?
He is unable to work, my lord. He is unable.
Have you not contested the matter before the court?
We have filed the objection, my lord. However, due to his disability, he did not go for examination and no cross-examination has been done here. To prove his financial capacity, my lord, no documents have been
Where is the order impugned?
Page number 12, my lord.
Page number?
12, my lord. To prove his financial capacity, my lord, no documents has been produced by the respondent by. As for my lord's one son is there, 5,000 has been granted to child. As regard to that arrears, I am ready to pay, my lord.
How much is granted?
5,000 has been granted to child, respondent number 2, and 10,000 rupees has been granted to wife, my lord.
When is the petition?
Petition
Petition.
has been filed on date. Date is, my lord.
That is the petition seeking maintenance that IA.
22 2021, my lord's petition has been filed for seeking maintenance.
So you are ready to pay that 5,000 to the.
Please, my lord, I am ready to pay 5,000.
The present RPFC is filed the delay of 310 days. When counsel submits that the petitioner is a physically disabled person and he could not contest the matter in view of his disability. Court had granted 15,000 without any basis and he is not in a position to pay the same. It is stated that the amount of rupees 10,000 is granted to the wife and 5,000 to the child. It is submitted that he is ready to pay an amount of rupees 5,000. Considering the same, they shall receive all further proceedings on the condition that he shall continue to pay 5,000 per month.
Child has attended the majority.
Huh?
Child has attended the majority.
When?
On day 4/2/2023, my lord.
It is submitted that he has attained majority on 4/2/2023. Considering all this, they shall receive all further proceedings on the condition that the petitioner shall deposit an amount of rupees 5,000 from the date of petition till the day he has attained majority within a period of 4 weeks.
8 weeks.
Within a period of 8 weeks, these fees are introduced to notice. Yes.
Number 17, admission number 8.
Sorry for interruption, madam. 715 minutes. Finally, warrant has been issued, madam.
Number 8.
15 minutes. Finally, warrant has been issued to the petitioner, madam. Meanwhile, I served the copy, madam.
It's not that. Court, as a matter of the procedure, never grants. It is only in that case because they say that he's a physically handicapped person. And what is your client is also suffering from anything?
No, madam. It is a
Then no. Yes.
Serial number 8. P. Number D.
Yes.
Yala Bellikatti.
Please, Your Lordship. I represent on behalf of Vice Your Lordship in second matter.
My lordship, as I'm going to get retired next year in the month of June, and in the before chambers, my lord, it was she was not ready to come with me, madam. Since I'm staying in Chalkera, she is not ready to join me. And the children have already attended the majority, madam. And already I'm paying to the girl person, petitioner number, sorry, respondent number 2, till her marriage. So totally I am giving 12,000.
How much is granted by the court?
12,000. So I become
So you have no objection to dismiss your case
both the
by confirming 12,000.
yes, no, both the cases.
Lordship, I represent on behalf of the wife, Your Lordship, wherein I have filed a second petition, Your Lordship. There are two children for the petitioner. There's a wife, Your Lordship. Both husband and wife are having two children, wherein both the children are pursuing their studies, Your Lordship. As admitted by them, the RPHC was filed before this Honorable Court in an earlier stage, Your Lordship, wherein it was held that till attaining majority, the son would be entitled for the maintenance.
When did
There
he
is
attain majority?
he has already attained majority.
No, according to her,
Please, Your
they have
Lordship.
been paying 12,000 from the date of order.
Please, Your Lordship.
So there are no arrears as of now.
Please, Your Lordship.
So what we have
They
to
are
do is,
clear.
so what we have to do is now, according to you, you are seeking enhancement.
Please, Your Lordship.
How much is the salary?
60,000, Your Lordship, as admitted by them, by him, Your Lordship.
50,000 and after June 2025, once I get retired, it will be half of my salary level. So it will be 25,000.
Lordship. As admitted by him, Your Lordship, 10,000 will be deducted towards other expenses. So in hand, his salary is 50,000, Your Lordship. And earlier, as per his Your Lordship, he has produced some additional documents, Your Lordship.
Then pay another 10,000 till.
Sorry, my lordship. As per exhibit R11 and R30, wife is already working as a tailor, my lordship. She is.
How much is earning?
That I don't know, my lordship, but she has taken
10 and 11 are loan rent agreement and
taken by wife, my lordship.
How much you are earning as per that?
as per them, exhibit R10 and 11
No,
rent
even let
agreement
us
and loan
take
passport.
that, let us take that wife is earning. How much? 10,000 she is earning?
Sorry, Your Lordship, just formal other stitching she is doing to
That's
4 to
what-
5, 4 to 5,000, Your Lordship.
Then 5,000
Please.
plus this 12,000 comes to 17,000.
But now,
Your salary is 50,000. Take home salary is 50,000.
Taken loan as well, my lordship.
That's what deducting that only we are taking it as 50,000. Now in this 50,000, one person, now you are paying 10,000, 12,000 to them. Then the remaining is 38,000.
Sorry, my lordship. Take home is less, my lordship. This gross salary is 50,000. So this
What will you take a loan?
it's not produced.
Two children, wife, they will live with 12,000. A single person can have 50,000. And giving that 12,000 to them, 38,000. Huh?
help is not keeping well, my lordship.
Uh-huh.
My help is not keeping well, my lordship.
No, we'll enhance some amount. Till the whatever it is, till the children attain, even for or else we'll do one thing. That 5,000, you will increase it by another 5,000.
Sorry, my lordship.
No, that you cannot say that. That's what is the order of the court. I'll increase it by 5,000. That you will be paying till you attain your superannuation. Later, then you continue to pay the same amount. Yes.
Lordship, for that child, that's a girl child, Lordship, even though she has attained a majority, she is pursuing her studies, Your Lordship, and the petitioner is burdened with, the wife is burdened with the college fees and everything of the son also, Your Lordship. So, may I request, because even,
No, it's already he's paying 12,000, right?
please, Your Lordship.
No, if this court is increasing it by another 5,000, 17,000.
May I request for another 10,000? No, it's my request, considering the circumstances,
then
because there are two children who are studying, they are not employed. It is his contention. Earlier, his mother was there, Your Lordship, now she is no more.
It is not nowhere, no law says it should be half of the salary of the husband, the maintenance should be given. That's why I said
I do agree with Your Lordship, but the thing is, considering the circumstances with regard to the studies of the children, once if they are appointed, they are serving somewhere means that can be reduced, Your Lordship. It's my prayer, Your Lordship.
We'll increase it by 5,000.
I'm sorry, my lordship. I did pass over on.
Tomorrow, no pass out. Tomorrow. Yes, next. Next.
Seal number 90. Only corresponding area.
Huh? Post after vacation. Yes. At request. Yes. Give a date. Don't repeat the same date. More than 2 matters. Yes. Yes.
Seal number
21.
Seal number 21. Santosh certificate.
No representation, just a smart after vacation.
28. Seal number 22. Urgent. Seal number 23. Mahesh Odeh. Mahesh Odeh. Jyoti respondent.
Directed to file the assets and liability as per the Supreme Court judgment. I wanted to receive the
Post matter after vacation at the request of Land Council the petitioner, the filing statement of assets and liabilities. Yes. Yes.
Seal number 24.
Huh?
Representing on behalf of LS Sulad, my lord.
It can be referred for mediation.
Yes, your lord. Kindly refer the matter. Yes.
Like a settlement, hence the matter is referred to the mediation. Party shall appear before the mediation center on 9th of January. Yes.
Yes, grateful, your lord.
Yes.
Seal number 26. Vigilance. Distributing.
Commissioner, in the connected matter, in the last occasion, my lord, this honorable court has directed me to furnish the, my lord, the paying of maintenance regularly. My lord, my client has paid maintenance, except, my lord, when he is residing with the respondent hearing. On that day, on that particular month, he has not paid the maintenance, my lord. Remaining, my lord, he has paid the maintenance. I will file, my lord, the certified copy of the order.
File in the registry.
They said 2 months due, madam. The August and September they are not paid.
The petitioner shall file the statement with regard to the payment of maintenance to the respondent in the registry. This is marked after vacation. Yes, right.
29.
Yes.
Seal number 27. Urgent. Seal number 28. Mallikarjun Raymond.
petitioner. My application for rejection of claim was rejected, my lord. Following that order, my lord, the petition.
What is the suit for?
Suit for partition separate petition, my lord. Between brothers and sisters, my lord.
You are there?
I am the bona fide purchaser of
When did you purchase the property?
My lord, I have purchased it in the year 2022, my lord.
22.
Yes, my lord.
Suit is filed in 23.
Yes, my lord. It was purchased.
So on what ground it has to be rejected?
One delay and
Delay of 22 document 23, that can't be a ground.
my application is at page number, my lord. 93.
93.
Application of section 7 to 11, page 3 and 3, my lord. Undervaluation, delay and up to my lord, no cause of action as a root of cost verification. Sisters are claiming it to be the joint family property, my lord, but it is a self-accord property.
That's not a part of order 7 to 11. That has to be decided in the reform.
But my lord, it is a self-accord property.
Who will decide now? According to them, according to you, it is. That can't be looked into. From the plain governments, how do you demonstrate?
The different number 7 has taken as.
Not different, sir, number 7. You have to look at the plain. What is the case of the plaintiff? And from that case, how do you demonstrate that it is?
My lord, she is claiming that, my lord, the said property was purchased out of the income of the family property, my lord. But the defendant 7 in his written statement specifically stated that.
No, but we can't look at the written statement while deciding a petition on order 7 to 11. Please come.
I have purchased the suit from the defendant.
But what to do? You have to wait. Agreed with orders passed. You want to withdraw or shall I dismiss it?
My lord, because.
Tomorrow.
Please.
Next. Yes. Yes.
Petition seeking questioning the order of passed by the principal district judge, my lords. Transfer petition was filed, my lords, by the plaintiff seeking transfer of proceedings of miscellaneous appeal, my lords. Now, my lords, suit is for the relief of damages for mandatory injunction and permanent injunction.
You're the plaintiff?
Please, my lords. The respondent 1 to 3, my lords, were the defendants there, my lords. Now, my lords, after fully hearing both the parties on merits, ad interim injunction is passed, and the defendants have questioned the order before the in the miscellaneous appeal proceedings, my lords. Now, my lords, if I may invite the lords to stand attention to one document, my lords, page number 18.
So then what happened?
My lords, I am relying on this document because there is a decree passed in my favor, my lords. What has been observed in that decree is that I am in possession of that property, and I cannot be evicted of suit property unless due course of law, my lords. Now, my lords, the defendants, my lords, are the purchasers 1 and 2. This decree is passed against their vendor, my lords. They did not choose to dispossess me, my lords, but in turn, my lords, they sold it.
Why it should be transferred?
My lords, the reason, my lords, and then another.
Where it should be transferred?
To any other court in the Belgaum division, my lords.
Why not in that court?
Because, my lords, similar suit, where same decree was passed, sought, my lords. And in respect of same property, the judge before whom the matter is posted, my lords, he has exercised his jurisdiction as original jurisdiction.
He will be exercising whatever jurisdiction. That can't be a ground for the court to transfer.
Now he has already exercised his original jurisdiction in that suit, my lords. And since
it all depends upon the facts of the case.
My lords, again, my appellate jurisdiction is vested in the same judgment. Original jurisdiction is already exercised with the connecting matter.
Which year is that?
Same suit, 2023. There are two suits. One is filed in the year 2022, one more is filed in the year 2024. Now, one connected matter, he has already exercised jurisdiction and he has rejected here. And another suit, miscellaneous appeal, is posted again before.
How can a original jurisdiction will arise in respect of the same property in two courts?
There are two different purchases, my lord. So two different suits are filed. One is OS 5 number 23, and one more was filed before the petition bench at OS number 5 24.
No, let me understand. You filed an application before the one suit is filed before the district court.
Please.
No, suit is dismissed.
Suit is pending, my lord. IA is rejected.
IA for interim injunction is rejected.
Was rejected by the same court. In another suit, IA interim injunction is granted. Now this miscellaneous appeal is posted before the same judge was rejected the IA and connected.
No, you and the person will stand in the similar footing. Why do you anticipate that the same order will be passed in your case?
Well, since the suit property involved is same and even the rates are same, my lords, and the entire case is same, only purchases are different. Now, my only grievance, my lords, is the presiding officer who has exercised his original jurisdiction by disposing of the IA. Again, appellate jurisdiction is vested to the.
That is not in respect of your case.
But parties are same, my lords.
Who parties are same?
The plaintiffs are same, suit property is same, only purchasers are different, and both the matters are connected. Both, my lords, OS 5/23 as well as OS 5/24.
No, but as far as your case is concerned, the suit is concerned, it is different. That is a original suit. It's a original suit before the court. But he is not exercising for the very same matter an appellate jurisdiction and a original jurisdiction. It's a different case. Facts are different. Yes. What's wrong in it? You will understand from the facts of the case. And you know no appellate court while exercising the jurisdiction while in that MA miscellaneous application. It all decide based on the facts of the case. And what is the reasoning given by the learned judge? How it is wrong will be appreciated by him.
Please, my lords, the grievance, my lords, is in connected suit, my lords, while disposing of, the defendants have come up with a contention, my lords, that they have invested huge money in constructing the multi-story building. Now, in this case, my lords, in the entire written statement, they never come up with such contention. And before this judge was already passed an order, they produced the order passed by him and purposely on the grounds for the first time they analyzed that they have invested the.
Let's see the order.
The written statement of the present defendants.
No, not written statement. What is the order on your application?
Order is challenged before this petition.
You just came before this court seeking transfer.
Only simply transfer.
That's why the office was raised an objection.
But since the earlier transfer petition which was filed before the principal district judge, it was dismissed.
No, you can file a revision provided that you have you already moved the court, the principal district judge.
We have already moved.
Where is that order? That is what I am asking.
Page number 14 to 26.
14 to
26. Page number 15, first paragraph.
Come to page 22.
The petition is that the petitioner for transfer of the appeal in MA number 47 of 24, pending on the file of first additional senior citizens to any other senior citizens court at Belgavi and the ground that inside the appeal. The respondents have produced copy.
No, what your contention is not in so many words like what you are submitting for the court. Point number 1 at 9. The respondents have produced copy of the order in OS number 502 of 2024 passed by so and so. Hence, the contents of the petition that he apprehends that he may not get justice.
Because they have produced the order copy which was passed by the same presiding officer again before this court. And for the very first time in their appeal, they come up with the contention that they have used it with money. But this statement is never forthcoming with the entire written statement filed in the I have produced the entire written statement.
When counsel for the petitioner submits that in respect of the very same property, one purchaser has filed a suit before which court?
First
additional senior civil judge, and the other purchaser has filed a suit before the second additional senior civil judge. The presiding officer, who is now this additional district judge.
Presiding officer, first additional senior judge.
How will the appeal go to him?
Suit was filed before the municipal court.
That's what I asked you. The one suit is filed before the municipal court, and the other suit is filed before the senior civil judge court. And the suit which is filed in respect of the filed by one of the purchaser before the senior civil judge, that suit came to be dismissed. Suit or the IA?
Suit is filed by us against the purchaser.
There are two suits.
Both filed by us against two different purchasers.
You are the owner of the property.
I am in possession of the property. My adverse possession I am claiming on this. And that is confirmed by a decree that was passed earlier in the year 2009. And it is also in turn confirmed in the regular first opinion.
I call that the petitioners who are in possession of the property have filed two suits against the purchasers. So how can you file? You are the plaintiff. How can you file two suits in respect of the very same property? One before the additional the junior civil judge of municipal court, and one before the senior civil.
One suit, initially that I had filed against only one purchaser. During condenser this suit, there is one more transaction that has taken.
Correct, but how will the courts will change?
What has happened is
Property is one and the same.
Yes.
And then
in one more suit, I have sought relief of declaration also. That's when the matter is supposed to be proceeding.
one suit is
One suit is for bare intention.
that initially he has filed a suit seeking bare injunction before the municipal court, and the second suit is filed seeking declaration and injunction before the senior civil judge court. That suit is dismissed or IA is dismissed?
IA is dismissed.
In that, an IA is filed seeking injunction. That was dismissed.
And in this suit, IA is allowed.
And the suit that is filed before the municipal court, the IA filed by the plaintiff is allowed.
Senior civil judge court, IA is allowed. Municipal court, IA is dismissed. Senior civil judge, IA is allowed.
Who is this judge? You're creating a lot of confusion on the facts. No, it's not that. There are two suits. One suit which is filed before the additional senior civil judge, your idea for injunction is dismissed. Then where did you go?
Well, other side has referred miscellaneous.
What has happened to that?
That miscellaneous appeal, my lords.
That you are seeking transfer of now. And then what about the other one?
In that it was dismissed, my lords. It was dismissed by the same judge who had exercised original jurisdiction.
Original jurisdiction has what? As the judge is not a senior civil judge.
He posted as first additional senior civil.
The additional, the senior civil judge has allowed the IA file for injunction. While the principal, the matter that's pending before the municipal court, the learned judge has dismissed the IA file for injunction. Against that, now the miscellaneous appeal is filed by the defendants. It has come up before the very same judge who has dismissed as a junior civil judge, and now who is discharging who is the presiding officer of the additional senior civil judges court. It is apprehension of the petitioner that as he has already exercised the original jurisdiction and dismissed, now if the same judge exercises an appellate jurisdiction with respect to the very same property and the parties, it would cause prejudice to him. The principal district judge had dismissed the application concerning the submission of the land council and considering the fact that exercising the jurisdiction of the original side with respect to the very same parties, the learned judge has dismissed the IA. They shall stay of all further proceedings in miscellaneous number 132 of 2024, dated 25th November 2024. That's what I said. That's what I said. Stay of all further proceedings in miscellaneous number so and so.
Proceedings of miscellaneous appeal. Not miscellaneous 132. Since that transfer petition is dismissed, it cannot be stayed. The proceedings of miscellaneous appeal have to be stayed.
What is the number of the miscellaneous appeal?
MA 47 of 2024.
MA 47 of 2024. They shall be stay of all further proceedings in so and so, so and so.
Okay.
Then the next day, the hearing petitioner is permitted to take out hand summons on the counsel appearing to the respondent and shall file a memo to that effect. This is matter on February 4th. Yes. Yes.
My lords, I am for the petitioner, my lords.
Yes.
My lord, I have filed this wife's civil petition to transfer the petition filed by a husband for a dissolution of a marriage in Bidar to Hospete city, my lords.
Distance?
My lord, 450 kilometers, my lords.
When is the MC filed?
My lord, in July 2024, my lords.
The present petition is filed. Seeking transfer of MC number 74 of 2024, pending on file of the principal family court, either to the senior civil judge court at Hospite. It is submitted that the distance between both the places is about more than 400 kilometers, and it is difficult for the wife to travel. Considering the submission, they should be stay of all further proceedings. So and so, to the next date of hearing. Petitioner is permitted to take out the hand summons on the counsel appearing to the respondent and shall file a memo to the effect. This is matter on 5th of February.
May I seek a hand delivery, my lords?
5th of February, hand summons.
Much obliged.
Next.
My lord, appeal to petitioner, my lord.
Yes.
My lord, it is a civil petition filed by the wife seeking for transfer of matrimonial case which has been filed by the husband for dissolution of marriage, my lord. And the distance is 120 kilometers, my lord, from Gadag to Bagalkot, my lord.
Which year is this?
My lord, it is of November 12, 2024, my lord.
The present petition is filed seeking transfer of MC number
202 of 2024.
02 of 2024, setting on the file of the Principal Family Judge Kada to the Family Court at Carbon Court. It is submitted that the distance between the places is above 100 and is difficult for the wife to travel. Consider the same way shall be stay of call for the proceedings and summons. This
Please,
is
madam.
on 5th of February.
Please, madam. Much obliged.
Thanks.
One submission, my lords. In a previous matter, my lords, the hand summons has been ordered, and one of our contention is, my lord, there is a serious life threat to her in a Bidar city. So, my lords,
So, what is the response?
much obliged.
No hand summons. Yes, 33. You remember that is on 31, item number 31.
Yes.
Yes,
Much
sir.
obliged.
Where is the respondent?
This is petition filed by husband and
Where is the respondent?
maybe in the other court.
Shall I post it tomorrow or delete it from Partner and list it
No,
after
it's very
the
posted tomorrow.
tomorrow?
Even if pass over my influence, it is fine.
No Partner. Tomorrow. This is matter tomorrow. Yes, 35. No representation for the respondent. Yes, where is the petitioner? Shall I post it after vacation?
Please.
After vacation. Delete from Partner, no representation for the petitioner. Counsel with the respondent is present, post after vacation. Give a date. Yeah, it's 11th of February. Yes, next.
I appear for suit for declaration and authorization. Before that, I want to make a submission, my lord. Earlier, my lord, there was inter-alia dispute between the family members of the petitioner hearing. I was implicated, my lord, under unregistered sale, my lord. I was subsequently implicated in a suit. I took a contention, my lord. That's I am a flute owner, but court disputed my version only on what is unregistered. You cannot. Instead of filing a suit for specific performance, my party after disposal of their suit, he has filed a suit for adverse position. So I want to withdraw this suit with the liberty to file suit for specific performance. That is what my say.
What will happen to the limitation?
Good, sir. For limitation, that was the entire amount is paid. Nothing is been left. Only execution of sale.
File a memo to that effect. Let her respond and file your objections to that. We'll see.
Your Lordship, this is contention is for declaration of adverse question and permanent injunction, Your Lordship. Already OAS decree and FDP proceedings are going on. But there also they are not cooperating, and yet the contesting the suit proceedings here.
The CRP is arising out of a suit for.
This is declaration adverse question of permanent injunction.
That is filed by him. That is filed by him. He wants
not filed. That is a dependent appeal.
You are the
OAS's contention is they are not filed.
You are the plaintiff or the defendant.
Defendant. Defendant. Plaintiff rejected. They want to compromise decree. Second round of litigation. They are trying
I think you understand what the court is referring.
Please.
He says he wants to withdraw the suit with the liberty. To that effect, he filed a petition before this court. If you are objecting to it, you have to file your objections to that. Then considering your objections, then the court will pass an order whether the liberty can be granted to him or not. Can the court stop him from withdrawing?
That cannot be done.
But even my one solution. If my lordship permit, I will file before trial court, either before this honorable court application or 23 application itself.
If my clarification allowed and that directions will be given, Your Lordship. Instead of here I am filing objection against CRP, against that, it may be taken my contention and let them give an opportunity there and then CRP is allowed on that basis. That may be considered. They are also permitted there.
One solution. There is no interim order from this honorable. If my lordship permit any next week, by that time I file objection. Let them file their objection.
This is matter after petition. The petitioner comes for the defendant submits that he wants to, the plaintiff submits that he wants to withdraw the suit itself and file a fresh suit, and he wants a liberty to file a fresh suit seeking a specific performance. It is submitted that and the request time. This is matter after vacation.
When I request in this bill, then say
If stay is
I
granted, I cannot file application.
Then simply they are adjourning the matter.
They are not counsel for the respondent, plaintiff submits that. till such time, they will not proceed with this.
Please, stay ready.
I am recording the submission.
Yes.
This is matter on when? On
Date will be given.
10th February?
Much at least.
Yes.
Till then, they should not proceed any further.
We have any documents with the concern, page 1. Shall respondent?
For the respondent, madam.
You want to say something?
Let me complete. Because this is a petition challenging the orders in the matrimonial case under section 24. They have awarded rupees 3,000 per month to the wife and the respondent, and cost of litigation expenses 10,000 rupees. Only 3,000 plus 10,000 under section 24. According to him earlier, there was a proceedings under section 125, wherein she was awarded rupees 10,000. And as per the evidence, he is drawing more than rupees 63,000 rupees per month.
She is for the wife, he is for the wife.
He is for the husband. He has challenged that order.
3,000 order you have challenged.
Already there was a petition was filed by the 125. There is also granted 10,000.
And you are paying that?
Please no.
In up to date booking.
Then how can there be another 125 proceedings?
Yes.
No, when you are receiving 100, under 125, when an amount of 10,000 is granted to you,
yes,
and you want any enhancement, you should file a petition under.
No, he has filed another petition for divorce. In the divorce petition, we have sought for pendentity litigation.
The litigation that is fine.
3,000 rupees.
Was that disclosed before the court that you are getting 10,000 on in that?
Yes, no.
Let us see let's see the order. No. Let us see the impugned order. Is there any mention about this 10,000?
Yes.
In the article they have mentioned.
Yes, it is mentioned. But it is mentioned. We have not suppressed anything.
They have not mentioned.
Yes, but anyhow, it is in the knowledge of the court that you are paying 10,000.
Because at that time, application was that interim maintenance was pending. Only interim maintenance was completed. Now it's even
No, I can understand if what you are saying about granting of 10,000 is not reflected in this order, and it is your case that was not brought to the notice of the court. It is altogether a different aspect. Court has considered the fact that already you are paying 10,000, and in addition to that, court has granted 3,000. And admittedly, your salary is 50,000. So why should the court interfere with that?
What is the amount of awarded is not reflected because at that time that was pending.
Let's come to that order.
Please, at page 13.
Page number?
Page 13. Reason for.
In page number 13, madam. Para number
9.
Para number 9.
Para number 9. Is also claim of the petitioner that respondent has filed a granted interim maintenance of number miscellaneous 91 bar 17 on the file of principal.
Then that contention you have already taken.
Yes.
I have the application was filed by the respondent before the court was they are not they are suppressed. What the wanted to filed. And I have filed objection stating that was filed and interim maintenance for other. And that objection was filed that was pending.
No, we will consider the fact that 125 is ordered and 10,000 is granted. 125 proceedings, sir, they are altogether different proceedings. Now, before this court, before the family court, when in the pending MC, court felt that 3,000 is a. Now, even let us consider your salary, that 10,000 and this 3,000. It comes to 30,000. How it is wrong?
That much litigation charge is not whatever the court will grant and working out. But once the second application was already.
You can't consider it as a second application. That's why, though your salary is. Because that's the reason why the court had granted only 3,000. Had it been a case, when your salary is 60,000, why would the court grant 3,000 as maintenance?
The court has not even finding that already considered.
No, we will consider. We will consider now.
Regarding that, some citations are there because there is no notes granted.
No citations are there.
already once I'm going to pay for
The court has to consider whether that amount which is awarded in the earlier maintenance and now looking at your salary, is it amount, does it cause any kind of inconvenience to you? Now, 10 plus 3, 13,000 for a person who is having a salary of 67,000.
If there is no it is very because she is only one person, there is no children and and she has getting 65 acres of land in their parents' house. She come around 20 acres of land. She has sufficient income everything was. Even though that 10% is an higher side. Now again, once again, 3,000 plus 30,000 is an higher side because he is also maintained by everything, parents and everything else. Because 10% is already higher side.
I'll record that. Please come.
And that was 3,000 is what I was regarding notes, the second application is section 24 is not.
I'll record that it is not maintainable. That your contention I'll record.
Because even though notes even 3,000 or 30,000 is a higher side because she already sufficient income in every notes and she herself deserted notes and because under the ordinance of children, there is no children and everything else.
You agreed with the orders passed. Agreed with the orders passed in 9 number 1 in MC number 10 of 2019, whereby the wife is granted maintenance of an amount of 3,000 and 10,000 towards litigation expenses. The husband is before this court. The
page number 14 minutes.
The husband has filed MC number. You filed MC.
Yes.
Filed MC number 10 of 20, 10 of 19, seeking divorce. In that wife has filed an IA seeking the maintenance of an amount of 10,000 and 20,000 towards litigation expenses. The husband has filed his objection stating that already wife had filed criminal miscellaneous number 91 of 2017 on the file of the principal civil judge and JMFC attorney and Mathani, and the second application for maintenance is not maintainable. The family court
at page number 14 minutes. 14
has observed that the petitioner being the husband of the husband has to maintain the wife. He cannot be permitted to say that he is unable to maintain his wife as long as he is capable of earning.
earlier.
Though it is stated that he is having sufficient income, he has not produced any material. Though the husband has stated that the wife though claimed that husband is having sufficient income, but he has not produced any material to substantiate the same. And considering the same, an amount of rupees 3,000 per month is awarded as maintenance and 10,000 as litigation expenses. Next para. When counsel applying for the husband submits that the wife is having sufficient income, and apart from that, in criminal miscellaneous, an amount of rupees 10,000 is granted as maintenance. Now again, another 3,000 cannot be granted. He submits that granting of maintenance of an amount of 13,000 is on the higher side. It is further submitted that the consecutive applications for maintenance cannot be made, cannot be filed, and cannot be entertained. And this aspect was not considered by the court. He submits that in the petition that is filed, the wife had suppressed the fact that the husband, that she is already awarded maintenance of an amount of rupees 10,000. Then counsel submits that the order reviewed needs to be set aside. Next paragraph, counsel appearing for the respondent husband submits that the respondent wife submits that the husband is earning salary of an amount of rupees
67,000 and more minutes.
67,000.
There is no mention that 63,000
Yes, earning an amount of
not
is earning 63,000 per month. The gross salary is 63,000. It is submitted that the court, having considered the fact that already criminal miscellaneous is filed, had granted the amount, which is a meager amount, which is only 13,000 put together, and for the salary of 63,000, 13,000 maintenance granted to the wife is not on the highest side. And in fact, the court ought to have granted a more amount. He submits that the petition needs to this petition is liable to be dismissed expert. Having heard the concerns on either side, produce a material on record. Whether now both the order passed by the court granting 3,000 and the order of maintenance granting an amount of 10,000 or before this court. The contention of the petitioner that there is a suppression with regard to the amount that is granted. In the order, there is a mention about the objection that was stated, wherein he stated that already maintenance is granted to the wife in criminal miscellaneous. Be that as it may, the fact remains is, in the earlier proceedings 10,000 is granted, and this proceedings 3,000 is granted, and the salary of the husband is 63,000. Even on that count, and in the considered opinion of this court, the amount of 3,000 that is granted to the wife, in addition to 10,000 that's already granted, cannot be found fault with. In that view of the matter, this court finds no reason to interfere and accordingly dismiss.
Dismiss.
Next. No representation after vacation.
Number 39. Then Swami. Board key.
No representation for the respondent. Counsel for the petition is present. This is matter on 7th of January. Yes, 40. After saying no representation on behalf of either of the parties, this is matter on 7th of January. This is not 7th January. This is on 27th February. Yes. Any matters? No signature.
Password.
230. Send it to the paper.